Hello?
Hello?
Yes.
Hello?
right, good morning and good afternoon, ladies and gentlemen. My name is Judge Jessie Law, and we are going to begin with the Fulton County State Expedited Accusation Calendar. Expedited Accusation Calendar is a list of criminal misdemeanor cases, individuals who were recently arrested and booked at the Fulton County Jail. Upon being booked, the prosecutor, who is the Fulton County Solicitor General's office, has formally accused the defendants of one or more misdemeanor charges. Hence, the case is now before the Fulton State Court. This would be the defendant's initial appearance, at which time I will inform the defendant of the charges, his or her case number, as well as to address the issue of bond, whether any conditions will attach to the bond, and if possible, to give you a specific court date. If you are a defendant charged and arrested with certain misdemeanor offenses, I am going to be addressing your cases on a one-on-one basis. Please remember to remain, okay, I'm going to stop for a moment. For individuals who have appeared via Zoom and you appear to be driving, we are going to remove you from the Zoom calendar. Please also remember that if you want to appear on this calendar, that you need to be seated in one position instead of walking around because it's very distracting. So you can switch off your video until you want to address the court. Ms. Watsika Robinson, please switch off your video while you are moving around because we really don't need a tour of your home. Okay, getting back to my cases. Thank you. If you are a defendant charged with one or more misdemeanor offense, please remember these rights. The first one is the right to remain silent. Anything you say during the course of this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. We have attorneys from the Public Defender's Office and a conflict defense list who may be appointed to represent you. So we are going to begin with Courtroom 2. Who do we have, please? Who do we have in Courtroom 2? Francois, if you'd like to unmute Courtroom 2, can they hear me? Ms. Gang, could you hear my announcement?
Good afternoon. Yes, Your Honor.
Okay. Mr. Sabat, could you hear my announcement?
I couldn't, Your Honor, no.
You didn't hear my announcement at all?
I couldn't. I think it broke up.
Okay.
The internet might have lagged.
Courtroom 2, could you hear my, Courtroom 3, could you hear me? Okay, I'm going to start again. Gosh. Good afternoon, ladies and gentlemen. I'm Judge Lal, and this is the State Expedited Accusation Calendar for cases in which individuals have been recently accused by the Solicitor General's Office of Fulton County. This will be the defendant's initial appearance before a judge, at which time the defendant will be informed of the charges brought against them, who is their attorney, as well as give them a bond and possibly a court date. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. We have attorneys from the Public Defender's Office or the Conflict Defense List who will be representing you. How is that, Mr. Sabat? Could you hear me?
Crystal clear, Judge. Thank you.
Oh, amazing. Okay. All right. Courtroom 2, Deputy Francois, are we ready? All right, Courtroom 3. What's going on? No idea.
I'm sorry, position number 1, please. Thank you.
Okay, good heavens, I thought. All right. Position number 1, we have Norma Brown, case number 22 CR 006038D. Ms. Norma Brown has been charged with driving under the influence of alcohol less safe from September 7th, 2022. Ms. Brown, you've been advised of your right to remain silent, and your attorney will be Ms. Wanda Gant. Mr. Tucson, any priors? First arrest, okay.
Miss Reed, good afternoon.
Good afternoon, Your Honor.
All right.
Okay, currently there is a bond on this case, it's a surety bond for $3,500, and the state is requesting that that remain. The day of the incident was yesterday, that's September 7th, 2022, Georgia 400 northbound in Roswell. The officer reported to a scene of an accident. The caller, who was actually the defendant, had said her vehicle was in the left lane, close to the median wall, and she was unable to move her car out of the roadway. The second driver, Mr. Shane Williams, actually told the officer that the defendant said she had a couple of drinks and hoped the officer wouldn't be able to tell. The officer began to observe the defendant closer, and he noticed that she was a bit unsteady on her feet. The officer spoke with the defendant, and he detected an odor of alcohol, and he asked the defendant if she had been drinking and whether she had told Mr. Williams that she had been drinking, and hoped that the officer hadn't noticed. And she
Well,
did.
I read that part,
Okay,
but but she hasn't got any priors. So
No priors.
So it's
and-
3,000, the amount the state is asking for?
Well, currently it's 3,500. The state was asking for it to remain the same just because this occurred 2:00 in the afternoon and there was an accident involved, and it was just dangerous at that time of day to be out driving. So
It was a
that's,
single car accident, wasn't it?
no, I have not seen the incident report, but my understanding is that Mr. Shane Williams was also involved. He was the other driver.
Okay. Thank you. Ms. Gant?
Thank you, Your Honor. Miss Norma Brown is 66 years old. She has been in the Atlanta, Georgia area for 5 years. She has a sister. However, she states that her sister is not available to provide any financial support toward her bond. Miss Brown completed 12th grade. She is a retired public servant. She served as a police fire dispatcher for 32 years. She denies the allegations. Your Honor, she is presumed innocent. I am requesting a signature bond as this is Ms. Brown's first arrest. And if Your Honor determines that she is ineligible, I would ask for a bond reduction to no more than $1,000. Thank you.
Bond said $1,000 is a surety bond. No driving unless she has the privilege to drive from the Department of Driver Services. She would have to go through an administrative appeal with OSA before she's allowed to continue driving. Thank you.
Thank you.
Our next court date is September 22nd. Ms. Brown, if you do make bond, please be sure that the courts always have your current address. We will send you notice to appear in court. If you fail to appear, a bench warrant will issue for your arrest. Thank you.
Can we do add-on position number 1, please? Everybody on there?
Okay.
All
All right. Here we have Karen, Deidre, Richie. Are you Miss Richie?
Yes.
Ms. Richie, you've been advised of your right to remain silent, and your attorney is going to be
J. Kim.
Okay, there she is. All right. Your attorney is Ms. Kim. Ms. Richie has been accused of making an improper U-turn, operating without lights required by law, driving improper erratic lane change, DUI, driving under the influence of alcohol, and failure to report striking a fixed object. All right, she was seen back on June 20th, 2022, where Judge Morrow had given her a $2,750 signature bond through the jail. So, Mr. Tucson, anything else to add?
This is a second arrest.
All right, thank you. Ms. Mitchell?
Yes, Your Honor, since this arises from the same incident, we just reaccused the case to add it to her previous charges in her DUI case. So we'll just be addressing count 5, and there's a current bond of $1,000 surety as to count 5, and the state's going to request that charge be changed to a $250 signature bond to align with her other bond and to comply with existing conditions on the previous charges, which were just no alcohol, drugs, and weapons. The officers further investigated And it was reported that the defendant left the roadway and struck the pedestrian crossing fixture, and she left the scene without reporting it.
So I'm sorry, but is the state adding this charge to the current charges?
That's count 5.
Yeah, that's the additional charge, failure to report striking a fixed object, correct?
Yes,
Okay, and you are agreeing to a $250 signature bond through the jail.
correct.
And she's being held on other matters, is that correct?
On other matters, I believe it's just this. That
She
she's
have a
being-
driving improper lane change on the booking sheet.
so
Improper
we,
lane change, that's here, yeah. And she's got operating without proper lights, making improper U-turn, and DUI. So I just need to know, what else am I doing to her current case?
Your Honor, the 5th count, she has $1,000 surety. So right now we're just changing that to $250 surety.
Okay, that's what's
I mean,
holding her in jail then. 200, you're changing it to, you're agreeing to amend it to a 250.
Correct.
Okay,
So she should have a total of $3,000 signature bond
Yeah.
between all her charges.
understood. Ms. Kim, any objection?
No objection, Your Honor.
All right. Ms. Richie, these are charges that came about from June 18th, 2022. The state is going to agree to amend one of the bonds on this charge of failure to report striking a fixed object to a $250 signature bond through the jail. No driving unless you've got privileges to drive from the Department of Driver Services. Once you're released on this signature bond, make sure that you have maintain a current address with the court so that we will send you notice of when to come back to court. Do you understand?
Yes.
This is an open, active case against you, and you need to make sure that you respond to court summons at all times.
Okay.
And I don't know if you qualify for the services of the Public Defender's Office. You might want to recheck with them or retain your own attorney. All right, thank you.
Thank you.
Position number 9.
Hayley Ann Mason is accused of criminal trespass on September 7th, 2022. Ms. Mason, you've been advised of your right to remain silent, and your attorney is Ms. Kim.
One minute.
Oh, it's Ms. Gant? I'm sorry. All right, and Mr. Tucson, first arrest, what are we talking about?
First arrest.
Okay, and who's the prosecutor?
It's my case, Your Honor.
All right, Ms. Duncan, what is your recommendation?
Yes, Your Honor. In this case, the state is going to be requesting a $3,000 signature bond through pretrial, given that this is the defendant's first arrest. However, it is a dual arrest with position 13, defendant Parker. For the record, they broke into the VIP spa that is owned by Crystal Kimbrough. Crystal is Christyl. Kimbrough, common spelling. And at that location, there were signs posted and many signs that said no trespassing allowed. They broke the window to get in and are accused of breaking in and sleeping in that building. So therefore, given her limited criminal history, we're going to request that $3,000 signature bond through pretrial, a no further contact with Crystal Kimbrough, a stay away from the incident location located at 1916 Piedmont Road Northeast, no alcohol, drugs, or weapons, and no further violations of Georgia law.
Give me the address again, please. I'm that was so fast. Sorry.
My apologies. It's the VIP spa located at 1916
Yeah,
Piedmont Road Northeast in Atlanta.
Piedmont, okay. All right. Ms. Gant, I'm going to grant the state's request. Any objection?
No objections, but we've asked for a one-time law enforcement escort for Ms. Mason to retrieve her belongings.
What were her belongings?
She informs me that she has belongings there. I'm not sure exactly what the belongings are. Ms. Mason, may you state to the court the belongings that you need to retrieve and just the belongings?
So I have my blade that I use with the security is left there, and some pieces of clothing. I don't exactly know. I put all my stuff in a corner, and the officer
Okay,
didn't.
that's just, so some clothing and a blade?
Yeah, yeah.
Okay, thank you.
Maybe some sunglasses too. And sorry for the record, we did
Ms.
not.
Mason, Ms. Mason, please remain silent. We're just trying to determine your belongings there.
Ms. Mason, bond is set at $3,000 signature bond through pretrial services. However, I understand she's residentially challenged.
Your Honor, she does have, she informs me that she is not residentially challenged. I do have a mailing address for Your Honor. I will place that in the chat.
And what kind of address is that? Is that where she lives, where she receives mail?
Where she receives mail.
All right. Okay, Ms. Mason, we are going to accept the address, and can you send the address to Holly Bridgewater, please?
Yes, Your Honor.
Thank you. And once this address is in the system, we will be sending you your next court summons to that address. Do you understand? If you don't show up in court, or if you don't report to pretrial, we issue an outstanding bench warrant for your arrest, and your $3,000 signature bond will disappear. I need some acknowledgement that you understand what I just said.
I do. Could I say something else about?
Ms. Mason, please remain silent.
Just
Remain
want you
silent.
to respond to my question. If you want to say something, it's best to say it to your attorney. Otherwise, you're going to jeopardize your case.
Okay.
Your bond is $3,000 signature bond through pretrial. You are not to return to VIP Spa at 1916 Piedmont Road Northeast in Atlanta, Georgia. You can return one time only with a police officer to retrieve your personal belongings. I don't know if the place has been locked up. If the place is locked up, then that's it. I don't know how you're going to be able to enter the location. But if a police officer is there and the place is locked up, then that's it. No more returning. Do you understand?
Yes, ma'am.
And your belongings will stay there, and you can go through your attorney to try to retrieve it. But I cannot guarantee that the place will be open for you to retrieve your belongings. Do you understand?
Yes, ma'am.
If you get arrested again, if you don't report to pretrial, or if you don't come back to court when summoned, we will issue a bench warrant and set aside your signature bond. You are to have no contact with Crystal Kimbrough. You're not to contact her in any way, form, or manner, in person, through a phone, or through any kind of social media. Understood?
Yes, ma'am.
All right, thank you.
And Your Honor, may you clarify whether or not Ms. Bridgewater is on this Zoom call, or do I need to email her? I do not see her name in the.
You need to email her. She's not on the Zoom call. Sorry.
Okay, thank you.
Your Honor, as previously stated, this is a dual arrest with co-defendant position 13.
And is that your sale recommendation for Mr. Barrio Parker?
No, the state has a different recommendation for that defendant.
We'll wait for him then. Thank you.
Okay.
Who do I have in courtroom 3?
Position number 10, Judge.
All right. Denisha McNeese is accused of battery, domestic violence on September 2nd, 2022. Ms. McNeese, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. No.
Ms. Gant.
Ms. Gant, okay. I think I misread that.
Third arrest,
All right. Yeah, thank you, Mr. Tucson. Third arrest, what were the other two?
2017 shoplifting dismissed, 2009 shoplifting.
Okay, thank you. Ms. Duncan?
Yes, Your Honor, this incident did occur on September 2nd, 2021. The victim in this case is minor AP, who is 14 years old. The incident location is 1078 Hobson Street Southwest in Atlanta. In this incident, the victim in this case arrived at Crawford Long Middle School with a bleeding nose that would not stop bleeding. In addition to bruising and swelling under both of her eyes, the school nurse also indicated that there was a laceration on the front of her nose. In addition to the bleeding, it's indicated by the facts that the victim in this case notified her friend that she had been using her mother's hair products that morning, and her mother got upset with her and grabbed her by the hair and punched her in the face 8 times. And initially, her mother stated that she was not going to go to school. However, she convinced her mother to let her go because she said that she had a test. Once at school, she reported the incident to the counselors as well, who reported the incident to the school administration, who contacted DFACS. It's indicated in the police report that there is a stepfather who dropped the victim off at school that day. We have been trying to get in contact with DFACS to get some kind of information about what provisions were put in place. However, at this time, we don't know what those were because the case is being transferred to a new caseworker as the previous one no longer works there. Officers did take pictures of the victim's injuries in this case. It is indicated that the defendant may have other children in the home as well as a stepfather. Given the nature of the offenses alleged and the injuries alleged to the victim as well as her age, we have a concern about the risk of reoffense and intimidation of this witness. The state understands that parents are allowed to discipline their children, but the state is of the mind that these types of injuries go beyond any type of corporal punishment or any discipline that could be provided to a child for using a hair product. For those reasons, we're going to ask for a $6,000 total surety. No further contact with the victim in this case, minor AP. And we're also going to be asking for the defendant to comply with any DFACS regulations put in place in this case. No alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Gant?
Thank you, Your Honor. Ms. Denisha McNeese is 30 years old. She has been in the Atlanta, Georgia area her entire life. She's married and has been so for 8 years. She is the proud mother of 7 children, ages 14, 11, 8, 5, 4, 3, and 1. Ms. McNeese completed high school. She also has an associate's degree in medical assisting. She is currently studying to enter into nursing school. She's currently employed at Oak Street Health as a medical assistant and a phlebotomist. She has been in that position for 4 months. My client strongly denies the allegations, Your Honor. She informs me that DFACS indeed conducted an investigation to close the case. She states that my client states that she has evidence basically indicating that these allegations are totally false as made by minor AP. This incident occurred back in 2021. My client was unaware of the warrant. In fact, the way that she came into custody is that she was pulled over and learned about the warrant at that time. Your Honor, my client also tells me that when her child returned home that evening, she did not have any injuries to her. And also she stated that she viewed photos that DFACS took and there were no injuries as stated. Further, Ms. McNeese states that when minor AP becomes upset, her nose bleeds. Now, my client does not have any prior convictions for violence. She is recommended for a signature bond. I am requesting one on her behalf. I did reach out to her husband, Mr. McNeese. He should be on the line along with minor AP to inform the court that they have been in contact with each other without incident. Therefore, I believe that the state's contentions regarding reoffending and intimidating the witness are totally unfounded. In closing, I am requesting a signature bond on Ms. McNeese's behalf as she is recommended. I am opposed to any no contact orders and would ask for a no violent contact and of course, no stay away orders. Thank you.
A bond is set at $5,000. It's going to be a signature bond through pretrial services. No violent contact with AP and no violent contact with anyone who is 16 and under. No alcohol, no drugs, no weapons. And she'll report to pretrial once a month. We'll need make sure that we have a current address on Ms. McNeese at all times. And we will send you summons as to when to appear in court. Ms. McNeese, I understand this, your position. However, you need to understand some other collateral matters. This is a battery domestic violence situation. If you have aspirations to get a professional license in nursing and so forth, this type of case is going to create a big obstacle. Do you understand? So you need to work very hard with your attorney to get this resolved. Any violations of your bond conditions could jeopardize you in this particular case. All right, so make sure you show up in court, make sure you comply with the conditions, and make sure you work very hard to resolve this, because this is going to create a major obstacle for any of your aspirations that your attorney has just outlined. Thank you.
And Your Honor, the state would just like to note for the record its objection to the signature bond where violence and injuries are alleged.
Noted. Next case, please.
Thank you, Your Honor.
Position 18, Judge.
Christa Amberjai Willis. Is that correct? Ms. Willis has been accused of simple battery and theft of services from May 28, 2022. Ms. Willis, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim.
Kim, yes. Thank you.
And Mr. Tucson, I understand no priors.
Second arrest, 2015 simple battery DV. It was dismissed.
All right, thank you. Ms. Mitchell?
Yes, Your Honor, in this case, the defendant battered an employer at the Lacquer Nail Bar located on 1700 Northside Drive, Northwest Atlanta, Georgia. She battered Miss Lay Trinity, spelled Letrinthi. Excuse me for the pronunciation, but she battered her by slapping her in the face. The defendant also received nail salon services by getting her nails done and walked out of the nail bar to avoid paying the $160 service fee.
Ouch.
The state's
I just said ouch, that's all.
Okay. The state's bond recommendation is, as to count one, a $2,000 surety, count two, $500 surety, totaling a $2,500 surety bond. No further contact with the victim, Miss
Lee, okay.
A stay away from the incident location, Lacquer Nail Bar, a one-day anger awareness, and no alcohol, drugs, and weapons. And Your Honor, we're recommending the surety bond based on the violent nature of the allegations and the fact that she does have a simple battery arrest in the past. No, nothing further, Your Honor.
Thank you. Ms. Kim?
Yes, Your Honor. Miss Carissa Willis is 29 years old, and she has been here in Georgia for more than 15 years. She has two children, 8 and 6. 6 years old, gonna be having a birthday party next weekend. And right now, she has an employer. She's actually a recruiter for a corporate company. And also she has been doing the recruiting for like 4 years. And she graduated from, she has some college education for human resources, and that's what she's doing right now. And Your Honor, my client denies allegations. She paid in cash, and actually it was my client who had injury in her nails. She had her children with them. They can be their witnesses. She did not lay on the hand on the Miss Lee, the complaining witness, and we would like to request for a signature on bond as she is recommended, and her previous charge was dismissed, Your Honor. Thank you.
$1,000 on each count. It's a $2,000 signature bond through pretrial. She's to report to pretrial once a month and maintain a good address so that we can send her court summons. This is still an open, active case. And she, well, it's not DV, so just make sure that she stays 200 yards away from the Lacquer Nail Bar at I think it was 1700 Northside Drive in Northwest Atlanta.
Correct.
Have no further contact with Miss Lay, L-E, middle name Trinh, last name Thi, and no contact with Mindy Tran, Tran. Ms. Willis, this is an open active criminal case against you. You are required to make sure you comply with the conditions of bond. If you get arrested again, if you do not report to court, or if you do not report to pretrial once a month, the signature bond will be canceled and converted to either a surety bond or a cash bond. Any questions about your bond?
No, thank you.
Your Honor, are we adding the AA, the 1-day AA and?
You know, I do that for DV cases.
Okay, gotcha.
They don't allow me to do it for non-DV cases.
Understood.
All right, next case, please.
Oh, you did it for McNeese? I didn't hear that.
Repeat.
For McNeese, number 10.
Number 10.
I didn't know you gave her anger awareness.
I didn't give her anger awareness, no.
Oh, so you did. Okay.
I did not.
This is position 14, Mr. Pfeiffer. He is a private attorney case.
Your Honor, good afternoon again. Sudhir Sabak on behalf of David Pfeiffer.
Yes, sir. Thank you. My sounding board for audio. Thank you. And did we say Piper or
Pfeiffer.
Pfeiffer? David Pfeiffer, is that correct? All right. Mr. David Pfeiffer is accused of simple assault from September 3rd, 2022, case number 22 CR 006034G. Mr. Pfeiffer, you've been advised of your right to remain silent, and your attorney is Mr. Sudhir Sabak for the firm of, I would like to know, Sabak Law. Okay. Okay, and Mr. Tucson, any priors?
No.
And the state, any recommendation?
Yes, Your Honor. In this case, we're recommending a $1,500 surety bond, no further contact with the victim, Mr. Allen, spelled A-L-A-N, Einstein, common spelling, 1-day anger awareness, and no alcohol, drugs, and weapons. Your Honor, although this is a first arrest, the defendant in this case, I'm sorry, one moment.
It's an assault case, right? It's not
Yes.
battery. It's not,
Yes.
Okay. So, and it's the first time. So we want a $1,500 surety bond. Is that correct?
Yes, we
Okay.
are requesting that because of the statements that he made, which were tantamount to a hate crime. He specifically stated, "You effing Jew boy, don't tell me what to do," when the defendant, being a doctor, was called to help assist him when the defendant hit his head in the pool. And so, you know, this being a hate crime will be decided by the trial line, but this behavior is reprehensible, especially towards someone offering aid. So that is why we're requesting a surety bond. Thank you.
All right, thank you. The bond's going to be set at $2,000. It's going to be a signature bond through pretrial services. Mr. Pfeiffer, you will report to pretrial once a month.
Your Honor, if I may be heard.
Do you want a surety bond?
No, I'm just a couple points. As far as the no contact with Dr. Einstein, that's not a concern, Your Honor. They live on opposite ends of the neighborhood, from my understanding. One goes right, one goes left. It's divided by.
I was going to do no violent contact.
That's fine. And what I was going to ask, Your Honor, I don't believe any travel restrictions would be necessary.
Not going to impose those.
Ma'am?
I'm not going to impose those.
Okay, that'll be great, Judge. And I'll file my entry of appearance as soon as we get off the hearing.
Understood.
Your Honor.
Is this the swimming pool at their subdivision?
That's correct.
Is it the clubhouse or is
Yes,
someone's some
that's
friend's
correct.
swimming pool?
No, Your Honor.
Mm.
Your Honor. this
Oh,
is
Dr. Einstein, please listen very carefully to what I'm saying, and then I'll hear your comments, okay? Very
Yes, ma'am.
carefully. All right. So, like I said, a $2,000 signature bond through pretrial services. I'm going to allow for no violent contact with Dr. Einstein, which means there cannot be any physical or verbal altercations with Dr. Einstein. And Dr. Einstein, the reason I'm saying no violent contact is because you have your own oath to look after patients and so forth. The resulting outcome, well, that's what we deal with. But if we ever see Mr. Pfeiffer unconscious, hypothetically unconscious on the road, there's going to be obviously you having to treat at least Good Samaritan way. Okay, so that's where I'm coming from. But Mr. Pfeiffer is not to have any physical or verbal altercations with Dr. Alan Einstein. He is to stay away from the clubhouse at his subdivision. He is not to use any of the facilities, the common facilities at his clubhouse, including the tennis courts, the swimming pools. I don't know what y'all have there, golf, you know.
The amenities, we got it, Judge.
The amenities. He's not to use any of them. Yes, Mr. Pfeiffer.
It was a private residence pool. It was not the community clubhouse.
Whose private residence was it?
Robert Eng, ENG.
Okay, you are not to go back to that pool. You're not to go back to that house. Is this someone's house at 141 Overhill Point?
Hold on.
Yes, Your Honor.
All right, are you a neighbor at that house? Were you a guest, Dr. Einstein?
I was a guest and their house abuts to my house and on the backyard. So,
Okay. And so and does Mr. Pfeiffer live in that location?
not at that location. He lives on the other side of the neighborhood, I believe.
Okay, good. So he cannot come back. He can't be within 50 yards of Robert Eng's house. I'm assuming that's 141 Overhill Point.
Correct.
Okay, so stay 50 yards away from 141 Overhill Point in Johns Creek. He cannot have no violent contact with Dr. Einstein, and he cannot use any of the common amenities in the subdivision because Dr. Einstein might be there. All right. Any questions, Mr. Sabak?
No, Your Honor, everything's
All
right.
right.
Very much.
No illegal drugs, no alcohol, no weapons, and no firearms. If he owns any firearms, he needs to surrender them to the authorities or keep them in a safe deposit box. We will send him notice for his next court date, and we'll take it from there. Now, Dr. Einstein, do you have any other concerns that you need to raise?
Yes, Your Honor. My major concern, or two things. One is my safety and my family's safety, but I think you've taken care of that. And the second one is this hate crime issue, which I think needs to be addressed, and I don't know the legal way to do that. But what he did was reprehensible, and he also psychologically damaged multiple kids or young adults who are literally having post-traumatic stress disorder related to this, as well as I am. So I don't know.
Understood, Dr. Einstein. If this is classified as a hate crime, that will be something that the district attorney's office of Fulton County will address.
Yes, ma'am.
To consider as a crime. If this is considered a federal matter, that would be up to the U.S. Attorney's Office to decide. Presently, the only criminal charge that's been brought against him is simple assault. And if there is a charge of terroristic threats, then it's up to the solicitor or the district attorney's office to determine whether it should be a misdemeanor or a felony charge. Now, with regards to the repercussions from this alleged act or alleged incident, with regards to repercussions, I can only stretch the conditions of the bond so far. So I hope that if there are any victims who observed this incident and who were negatively impacted, that they seek the necessary consultation or treatment. Because right now, he is presumed legally innocent, and until the case goes to trial, he is not considered convicted of this offense.
Yes, Your Honor.
All right. All right. Thank you, Mr. Sabak.
Your Honor,
Mr.
thank you.
Pfeiffer,
Good afternoon.
you too. And Dr. Einstein, have a nice day. Thank you.
Thank you, Your
Next
Honor.
case, please.
Position 19, Yanez.
This is Eduardo Yanez. Mr. Yanez, I don't mean to be rude, but do you speak English comfortably?
Yes. Yes,
Thank
ma'am.
Thank you. Mr. Yanez, you've been accused of false report of a crime back on September 3rd, 2022. You've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Tucson, any crimes?
Second arrest, 2018 sale of marijuana. It was reduced to misdemeanor possession. It was dismissed.
Ms. Mitchell?
Yes, Your Honor, in this case, the defendant was falsely reported that his vehicle was stolen in order to protect his brother who was originally driving it and fled from the police and left the vehicle in a ditch. With that being said, the state is recommending a $3,000 signature bond and no alcohol, drugs, and weapons in this case. Nothing.
Thank you. Was he charged with willful obstruction of an officer too on September 4th?
Yes, Your Honor, we NOD'd that.
Okay.
It was duplicative of this
All
charge.
right, thank you. Bond's going to be set at $1,500. It's a signature bond through the jail. I think this is going to be an insurance matter. So, Mr. Yanez, make sure that you keep a valid address with the courts and you will get summons to come back to court. Ms. Kim, any objection?
Nothing. Your
Okay,
Honor.
thank you.
Thank you, Doc. Position 16, Smith.
This is O'Brien Leonard Smith, accused of criminal trespass and theft by shoplifting on August 18th, 2022. Mr. Smith, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Mr. Tucson?
21 total. Last arrest was October 2021, probation. 2020 DUI, misdemeanor possession of marijuana, felony and misdemeanor obstruction arrest. 2019 ag assault, theft by receiving, simple battery dismissed. 2016 false imprisonment, possession of a knife or a firearm, possession by a convicted felon, and a 2016 possession of a Schedule 1 controlled substance conviction.
Were those convictions?
The one with the false imprisonment?
And the possession of firearm by a convicted felon?
I'm not sure. It's not on the GCIC. I'll have to look in Odyssey. He went to felony earlier, got a $2,500 good bond.
I see it was null crossed, so
What
from
was?
2019, right?
Yeah, 2019 was.
Yeah, it looks like it was. Okay. That's good. Thank you. Ms. Mitchell?
Yes, Your Honor, there's a current bond of $1,000 surety on this case, 500 as to each count. And the state's going to request that that bond remain the same with a stay away from the incident location, which is Circle K gas station located at 74 North Side Drive, Atlanta, Georgia, and no alcohol, drugs, and weapons. As Your Honor is aware, the defendant entered Circle K, took a cup of noodles, prepared it, and ate it inside the store. He also grabbed a bottle of soda and drank it inside the store, and then he left without paying for it. The whole incident was captured on video. The reason we're recommending that the surety bond remain is because the defendant is a convicted felon. He was convicted of possession of felony drug in 2017. He actually pled nolo to it and then convicted of felony fleeing in 2017 as well. In addition to that, he does have an outstanding warrant issued August of this year for receiving stolen property out of Union City. And then he also has an open felony marijuana case from this year. He also has, in addition to our concerns of him being a flight risk, he has 2 FTAs in his history as well in 2017 and 2013. So because of our concerns of him reoffending and him being a flight risk, we are recommending that the surety bond remain. Thank you.
Thank you. Ms. Kim?
Yes, Mr. Smith is 33 years old. He has been here in Georgia for the last 25 years. He has 3 minor children, and he has been receiving SSI for disability he has ever since he was 12 years old, Your Honor. And he completed GED and he does not make any income right now. We would like to request for signature on bond considering his disability, Your Honor. Thank you.
Bond is set at $250 on each count. Is a $500 surety bond. Stay away from 74 Northside Drive in Atlanta, Georgia, which is the Circle K. He was trespassed from the property on August 16th, so he cannot return to that property at all. Do not go back to Circle K. You need to pay for the $500 surety bond. You've got an extensive criminal history record with a likelihood to reoffend. Thank you.
Thank you.
Position 15, Russell.
Oh, his next court date is September 22nd, Ms. Kim.
Thank you.
Sorry, Francois, repeat that number again.
Position 15, Russell.
Okay. Darius Russell, middle name Contreras, is accused of theft by taking in violation of certain rules at a bus, rail, or station on September 7th, 2022. Mr. Russell has been advised of his right to remain silent, and his attorney is going to be Ms. Kim. Priors?
7 total between Georgia and Tennessee. 2019 trespass. It was accused as disorderly conduct in DeKalb County, so that appears to be open, I guess. 2015 probation for disorderly conduct. 2014 probation, same thing. 2014 DUI. That was this. Hold on. That was dismissed. He pled no to the disorderly conduct. And the Tennessee arrest was back in May out of Chattanooga. Forgery, theft of property, criminal simulation attempt. He was only convicted for the criminal simulation, and he's homeless.
All right, Ms. Mitchell?
Yes, Your Honor, in this case, the defendant went into the restrooms at MARTA 5-Point Station located at 30 Alabama Street Southwest, Atlanta, Georgia, and began kicking in bathroom stall doors, disturbing normal transit operations and patrons. Mr. Roy Scott Jr., an employee at MARTA, confronted the defendant and showed him his work ID badge, at which point the defendant snatched the ID badge and walked away with it. Your Honor, the state is recommending as to count 1, $1,000 signature bond, count 2, $1,000 signature bond, totaling a $2,000 signature bond, no further contact with the victim, Mr. Roy Scott Jr., a stay away from MARTA in accordance with any active suspensions, a BHET, 1-day anger awareness, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Thank you.
Yes,
Kim?
Mr. Russell is 43 years old, Your Honor, and he has been here in Georgia actually all his life. He has 4 children. 2 of them are adults and 2 of them are minors, 8 and 6 years old. And he got a job as a voter registration worker, and he has been working there for 1 week. And he's really excited about that job because it has been kind of a long time for he was not able to go get a job. So he wants to keep his job, and he went to college for culinary arts. He could not get the degree, but he studied for that. And we would like to request for signature on bond. We are actually making sure that he gets housing resources from social worker services. Thank you.
All right. On the theft by taking, that's going to be $750. The violations of the rules, that's going to be $250. His total bond is $1,000. It's a surety bond. And to stay away from all MARTA property. Next court date is September 22nd.
Thank you, Your Honor.
Okay. Position 13, Parker.
Sir, stay. Got your watch?
Barrio Parker is accused of criminal trespass on September 7 in case 22 CR 006035D. Mr. Parker, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Any priors, Mr. Tucson?
24 total. You got an open case, possession of a firearm and reckless conduct, 22 CP 207435. On probation, possession of cocaine, possession of a Schedule 2. That's in DeKalb County.
Mhm.
Also a theft by taking and battery, Fulton, 21 SC 177386. He has a hold. 2021 fade to appear.
From
20
where? Superior Court? Or another?
DeKalb County.
DeKalb. So he's got a DeKalb hold?
No, yeah, DeKalb. He was fade to appear from DeKalb. I'm not
Oh.
sure what the hold is.
Okay.
2019 criminal damage to property 2nd degree out of DeKalb and a burglary 2nd degree. 2019 failure to appear. 2018 possession of cocaine, possession of a Schedule 2 controlled substance, misdemeanor obstruction, marijuana conviction.
That's good. Thank you. Miss Duncan, I understand that the marijuana charge has been NOD'd, correct?
Yes, Your Honor.
Okay, so we're only dealing with the criminal trespass. He's got a $500 surety bond. Shall we keep it that way?
No, actually, the state is going to be asking to increase that $500 surety bond to a $1,500 surety bond. According to our research, this defendant has 7 FTAs since 2010, and the latest being in 2021, as well as 2 probation violations in 2021. In addition to several convictions, we have a concern that this defendant will reoffend given its criminal history and his lack of compliance with the legal process given the probation violations. We also have some flight risk concerns. So here we think the $1,500 surety is more than reasonable under these circumstances. Additionally, we're going to ask for no further contact with Crystal Kimbrough, the owner of the VIP salon. We're going to ask that he stay away from that VIP salon at 1916 Piedmont Road Northeast. And no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing
Thank you.
further from the state.
Okay, I'm going to keep the bond at 5. Hang on. 1, 2, 3, 4.
May I?
I gave her a signature bond, right?
Yes.
Is this a conflict case?
It's a dual case with position 9.
No, I meant Miss Kim. Is this a
Yes.
conflict case?
No, it's not. It's my case, Your Honor. I'm
Okay.
representing.
Okay, I'm inclined to keep it at $500 surety bond. Any objection?
I would like to ask for a signature on bond, Your Honor. He is expected to be extradited to DeKalb County. They're
Mhm.
coming to pick him up. He cannot go anywhere, Your Honor. He is basically, he's not a flight risk. He cannot be. And today is his birthday, Your Honor.
Well, that's why it's not 1,500 as the state asked. So it's a $500 surety bond.
Okay, thank you.
Stay away from the VIP salon, no contact with Crystal Kimbrough. And his next court date is September 22nd.
Thank you, Your Honor.
Thank you, Judge.
Judge, you kept that at 500 goodbye?
500 surety, yes.
Okay. Position 12, Morris.
Marvin Morris is accused of battery domestic violence on September 5th, 2022, case number 22 CR 006045J. Mr. Morris, you've been advised of your right to remain silent, and your attorney is Ms. McLeod.
Yes, Your Honor.
All right, and Mr. Tucson, any priors?
Yeah, this is 3rd arrest. Last was in 1996. So he went to prison after that. So
right.
that's where the big gap come from. He got 18 years sentence in 1997. I think he was released in 2014. So.
All right, anything else since 2014?
No.
All right, thank you. Ms. McLeod, Ms. Duncan.
Yes, Your Honor, this incident did take place on September 5th, 2022 at 1392 Hawthorne Drive in East Point. The victim in this case is LaTonya Turner, LaTonya. According to the warrant, this defendant, she is the girlfriend and other person living in the household of the defendant, and according to the warrant, he struck her in the face with a closed fist, causing bruising and swelling to her face. Given this, Your Honor, we did not have an opportunity to speak to the victim in this case, so we have a concern about the risk of reoffending, given that they live together, and intimidation of the witness, given their relationship status, Your Honor. While the state understands that he hasn't had many convictions since being released from prison, the charges in which he was convicted for are concerning to the state. Therefore, we believe that a $3,500 surety in this case is more than reasonable. No further contact with Ms. Turner, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Your Honor, my client is 49 years old. He is gainfully employed in the construction business. He has his own home, which is the address that was mentioned by the prosecution, and the complaining witness does not live there. As a matter of fact, the complaining witness does not live in the state of Georgia. The complaining witness happened to be visiting, I believe, from Chicago or Detroit. And she wanted to leave. She was asking my client to provide her with a car for transportation. He told her he was not able to do so. She became angry and she attacked him by punching him. My client was simply defended himself when she attacked him. My client is not a violent person at all. And she has left since. She's gone back to her home. She does not live in the state of Georgia, Your Honor. My client has no violent history. He has remote arrests in the long past. He's been out, he's done his time, paid his debt, and he is a good citizen, Your Honor. I would ask the court to give him a signature bond so he can get out of jail and get on with his life. He is happy with no further contact whatsoever with this individual who does not live in the state of Georgia.
And
All right, thank
and
you.
has never lived in his home.
we have no indication that she was arrested in this matter, and given the warrant, as Your Honor knows, it states that they do live together. So we would.
She does not live in the state of
already-
Georgia, Your Honor. She was visiting.
You know, one side saying she lives there, one side saying doesn't answer my question. All right, so bond is going to be set at $6,000. It's going to be a signature bond through pretrial services. Mr. Morris is to have no further contact with LaTonya Turner. He's not to communicate with her in person, not through a phone, not through a computer device, not through a third party, and definitely not through social media. He is to stay away from 1392 Hawthorne Way in Atlanta, Georgia. He may return to the location one time only with a police officer. If the officer verifies that Ms. Turner does not live at that house, he may enter the premises and live there. Yes, Mr. Morris.
1392 Hawthorne Way is my home. That's my residence.
Did you listen to what I just said?
She's not there.
Did
LaTonya.
you listen to what I just said?
Mr. Mars, I'll explain to you what the judge said, okay?
You can bounce around your head and try to figure out what you think I'm saying, but it helps if you listen to what I actually say.
Okay.
You are to stay away from 1392 Hawthorne Way in Atlanta, Georgia. You may return one time only with a police officer. If the police officer verifies that no one is living at their house, that Ms. Turner is not living at their house, you may return to that house. But you are not to contact Ms. Turner in any way. You're not to consume any alcohol, no drugs, no weapons. And while you are released on a signature bond, you will report to pretrial once a month. You will attend and complete a one-day anger awareness program. You're not to consume any illegal drugs, and you're not to, well, you're a convicted felon, so you cannot possess any weapons or any firearms. Your next court date will be sent to you at your current address. If it's Hawthorne Way, great. If it's not Hawthorne Way, because Ms. Turner is still living there, then you will need to update us with your new address within 30 days of being released. Good. I think you heard what I actually say now. Thank you, Mr.
He does, Your Honor. Thank you, Your Honor.
And the state would just note its continuing objection to the signature.
Objection noted.
How much was that?
6,000.
6,000 signature bond through pre-trial. Next case,
17 Williams.
Okay, I think it's Miquez Williams, accused of battery, domestic violence, and cruelty in the third degree from September 7th, 2020. Mr. Williams, your case number is 22 CR 0060408. You've been advised of your right to remain silent, and your attorney will be Ms. Kim. Mr. Tucson?
Fourth arrest. Last arrest was in February. All his history come out of Ohio.
Okay.
February domestic violence. It was dismissed. Before that, 2019 domestic violence dismissed, and another 2019 arrest. Unauthorized use of a motor vehicle, joyriding. That was dismissed. And that's it.
Thank you. Ms. Mitchell?
Yes, Your Honor. I don't know if you saw in the chat, but we are requesting a breakout room for this based on MH issues stated by the victims.
Oh, okay. Was that the one being referenced? Okay. Francois, we're going to take Williams up later. Who's next?
Position 7 Jones. We're gonna do later.
Let me check that chat. I'm sorry. There's so many. Okay. Okay. Mondravius Stephen Jones, case number 22 CR 006043Y. Mr. Jones has got 4 misdemeanor charges brought against him from a September 6, 2022 incident. They are criminal trespass, simple battery, simple assault, and willful obstruction of an officer. You've been advised of your right to remain silent, and your attorney is Ms. Gant. Mr. Tucson?
His third arrest. Last arrest was August 12th, failure to appear. August 9th, battery DV. He just got put on probation for battery DV in state court on August 23rd. That's it.
Thank you. Ms. Duncan?
Yes, Your Honor, this incident did occur at 5 Lamar Avenue Northwest, that's LAMAR in Atlanta. In this case, officers were dispatched to the scene and they were greeted by one of the victims in this case. Her name is Sequoia Williams, Sequuoya Williams, common spelling. She indicated to officers that the defendant in this case was beating on the door of the property with a pole, and that he was there to see his ex-girlfriend. And at some point after she opened the door, he pushed her to the ground. She called the police and he engaged in a physical altercation with, I believe, her boyfriend, the second victim in this case, Mr. Christopher Favors, and was told to leave the property. When officers tried to get him to leave the property, he started to resist arrest and refuse the commands of officers. And in front of officers, instead of complying with the lawful commands, he chose to continue to taunt and to make violent advances toward Mr. Favors, so much so to the point where the defendant had to be tased in order for the officers to gain compliance of the defendant in terms of their demands. Ms. Williams did say to officers that this isn't the first time that the defendant has come to this location looking for his ex-girlfriend. The state is not clear on who his ex-girlfriend is, but we do have a concern if that's the person that he was convicted of a battery felony violence offense for in the last couple of weeks. Given that, Your Honor, we have a concern about the risk of reoffense in this case, given that it was stated that he's done this before, come to that location and caused issues, as well as intimidation of the victims and witnesses in this case. He continued to taunt them in front of officers with total disregard for their commands. And we do have a concern that he's a flight risk, given that there is a recent FTA from the 22nd of last month. In this case, there is a $6,000 total surety attached. However, the state is going to be asking that count 1 be reduced to 500 surety, and that count 4, the willful obstruction, be reduced to 500, making that a total $4,000 surety bond, 500 for the criminal trespass, 1,500 for the simple battery, 1,500 for the simple assault, and 500 for the willful obstruction, given that this defendant was just convicted of a violent offense in August of this year. Given those facts and the other factors present in the case, we're additionally going to ask for no further contact with either victim in this case, a stay away from the incident location, 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right. Ms. Gantt?
Thank you, Your Honor. Mondravius Jones is 19 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mother and a grandmother. We are unopposed to the stay away at the incident location. Mr. Jones completed 10th grade and currently he is employed at Vine City Association. He has been in that position for the past 2 months. Of course, he is due at work and very concerned about losing his job, being that he is still in the probationary period. He strongly denies the allegations. He states that he did not make any physical contact whatsoever with Ms. Williams. He states that when he arrived at the residence, Mr. Favors actually approached him with a machete and was threatening to do serious harm to him. He also states that Mr. Favors is the person who had the stick, and Mr. Jones later picked up the stick to basically defend himself because he thought that he was about to be slayed with a machete. I do acknowledge my client's history. However, he is presumed innocent. He does not have the means to pay $4,000 toward bond, Your Honor. I am asking for bond reduction, a total bond of no more than $1,500. And for the breakdown, it's $500 for criminal trespass and for the simple battery, and for the remaining simple assault and willful obstruction, $250 each for a total of $1,500. We are unopposed again to the no contact and the stayaways. My client does not have any desire to be in touch with the complaining witness nor Mr. Favors. And furthermore, we believe that the state's contentions that he is at a risk of reoffending and intimidation are unfounded, Your Honor. Thank you.
Each count is $500. That's a surety bond. The total is $2,000 surety. No contact with Sequoia Williams. No contact with Christopher Favors. To stay away from the entire apartment complex at 5 Lamar Avenue in Atlanta, Georgia. He's not to return to that complex at all. Yes, Mr. Jones.
Mr. Jones, please remain silent. If you have any concerns, I will give you a call. And if it's something urgent, I let the jail know and have them put you in touch with me.
All I wanted to say was it's a camera, it's a police camera right there. They can see.
Mr. Jones, please remain silent. Please remain silent. This is not about guilt or innocence. The judge has ruled, okay?
It's a $2,000 surety bond, as I was saying. He's not to have any contact with Sequoia Williams or Christopher Favors. He's not to contact them in person, not through a phone, not through an electronic device, not through a third party, and definitely not discuss them on social media. No alcohol, no illegal drugs, no weapons, and to stay away from the entire complex, whose address is 5 Lamar Avenue. So if it's an apartment complex, you cannot return to that entire location. Do you understand, Mr. Jones?
Yes, ma'am.
Next court date is September 22nd, 2022. Thank you.
Thank you, Judge.
Thank you, Your Honor.
6, Henry.
Antonio Laval Henry is accused of driving while license suspended or revoked, driving when expired, on no license plate or decal, and no automobile insurance on September 7th, 2022. Mr. Henry, you've been advised of your right to remain silent, and your attorney is Ms. McLeod. Any priors, or do you have this motor vehicle report?
I don't have a report. He got a 2020 fade to appear.
Watsika Robinson, please mute her screen. Thank you. Okay.
2018, 2018 failure to appear. 2018 suspended license. Another 2018 failure to appear. Suspended license conviction. 2016. 2016 suspended license NOLO.
That's good. No, that's good. Thank you. Ms. Reed?
Thank you, Your Honor. The state's asking for a split bond. As it relates to count one, we're asking for a $500 surety bond. As it relates to count two, a $500 signature bond. And as it relates to count three, a $500 signature bond. That's a total of a $500 surety and a $1,000 signature.
Ms. McLeod, any objection?
Well, I was hoping that he could get a straight signature bond, Your Honor, but if
Not with that history of suspended licenses. The memo has not been received.
I understand, Your Honor.
$500 signature bond on the driving expired or no license, $500 signature bond on no insurance. I'm going to make those through the jail. Driving while license suspended or revoked, that's a $500 surety bond. Condition to these bonds, well, no driving unless you have a valid driver's license, adequate insurance, and proper registration. If you decide to go for another ride, well, just make sure you have enough money for bond. Thank you.
Thank you, Your Honor.
Oh,
Thank you, Your Honor.
Next court date is September 22nd.
Thank you, Your Honor.
Joseph Meadows there? Or any?
Yeah, so Judge, position 6, you only got the $500 good bond, the rest are SOB through the jail, correct?
Correct.
Okay. And this is 11 Meadows.
Joseph Meadows, is that correct?
That's correct.
Sir, you're charged with loitering and prowling and criminal trespass from September 7th in case 22 CR 006046Y. And you have been advised of your right to remain silent, and your attorney is Ms. Gant. Any priors, Mr. Tucson?
33. Last arrest was August 29th. Theft by receiving out of Cobb. That's open. On probation in Fulton. Possession of tools for the commission of a crime. 19 SC 171449. On probation in Cobb for entering auto. So its history is entering auto, theft by taking, shoplifting convictions, parole violation, probations.
How far back did they go?
Man, at least 01. Well, hold on. Well, the 90s. Yeah, it's bad.
Does he have any open probation matters, you say? You said he has got a probation for
Yeah,
possession of
he's on.
tools?
Yes, in Fulton. And he had an open case for theft by receiving from the August arrest.
Yeah, that one I got. Okay, thank you. Ms. Duncan?
Yes, Your Honor, and this defendant is currently being held without bond. The state is going to be requesting a $4,000 total surety bond. That's $2,000 on each count based on this defendant's significant history and the recent entering autos in his history. He has a conviction from 2018 and 2021. This incident did occur at the Heritage Place condominiums located at 211 Colonial Homes Drive. In this incident, the defendant crawled under the gated locked gate of the Heritage Place condominiums at about 1:30 in the morning and was seen peering into vehicles and pulling on the doors. It's noted in the case documents that this defendant lives nowhere near that property and is not a resident of this condominium community. It's for those reasons, Your Honor, the state believes that he was there for an unlawful purpose, given that he was peering into other people's vehicles. Given his significant history and the fact that he does not live there, we're concerned about the risk of reoffense. He does have open cases in this instance, Your Honor, as we have a concern about his likelihood to respond to the legal process. As pretrial stated, he does have probation and parole violations, giving us that significant concern. And given the nature of the offenses alleged, we're going to ask for that bond and a stay away from the incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you, Ms. Duncan. Ms. Gant?
Thank you, Your Honor. Mr. Joseph Meadows is 47 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including a mother. He also has a 20-year-old son. Your Honor, Mr. Meadows obtained a GED. He is currently employed at GMA Placements. He has been in that position for the last 1 year. He is very concerned about losing his job. He does not have the means to pay anything toward bond, nor does he have anyone to offer support. My client denies the allegations, Your Honor, strongly. He states that he was there at that property visiting someone. He denies being on probation or doesn't believe that he's on probation. And I am requesting a signature bond on Mr. Meadows' behalf. And if Your Honor determines that he's ineligible, then I would ask for a total bond of no more than $1,000. That would be $500 for loiter prowl, $500 for criminal trespass. And we are unopposed to the stay away. Thank you, Your Honor.
On the loitering and prowling, that's a $1,500 surety bond. On the criminal trespass, that's a $1,500 signature bond through the jail. To stay 200 yards away from the entire complex at 211 Colonial Homes Drive in Atlanta, Georgia. No illegal drugs and no weapons, no firearms. Yes, Mr. Meadows?
Mr. Meadows, I would ask that you remain silent. We don't want you to say anything to jeopardize your case. If you have any questions about your bond, I'm happy to call you.
I'm just gonna state, I'm not on no probation. I don't know what they.
We've expressed that, Mr. Meadows, and your bond is based on factors that we discussed earlier during our call.
Thank you.
Thank you, Your Honor. I do apologize for the interruption.
That's all right. Thank you.
So,
His next court date is, his next court date is September 22nd. Who do we have?
Position 2, Carter.
Okay, thank you, Francois.
You're welcome.
Sapita Carter is accused of battery domestic violence from case number 22 CR 006037G from October 31st, 2021. Halloween, okay. Mr. Carter, you've been advised of your right to remain silent. Your attorney is going to be Ms. McLeod. And Mr. Tucson, any prior?
Third arrest. Last arrest was 2021, parole violation. He got ag assault, ag battery, possession of a firearm during the commission of a felony conviction. 2010. They gave him 20 years, 10 to serve, 10 probated. That's 11 SC 102766. Also for burglary, 11 SC 102871. And they're supposed to run concurrent to the other case. That's it.
Ms. Reed?
Thank you, Judge. The state's asking for a $3,000 surety bond, a no further contact with the victim, Quidisha Bates, Quidisha Bates, common spelling, and no drugs, alcohol, or weapons. The reason we are asking for the surety bond is because he is out on probation, probation for the 2011 SC case. Per the warrant, the defendant attacked Ms. Bates by hitting her in the face, and this occurred late, and she fell to the ground, and her pinky was later determined to be fractured. Now, per the incident report, Ms. Bates left the scene, and the defendant followed her, and he drove in front of her, brake checked her a couple of times. In our office, we have been in contact with Ms. Bates. They're no longer in a relationship, and they do not live together. However, Ms. Bates is expecting to give birth to their child in 2 months. I believe she is on Zoom if you want to sound for her.
Ms. Quidisha Bates? Ms. Quidisha Bates?
Yes, ma'am.
All right, Ms. Bates, if you'd like to address the court, you would need to start your video. Otherwise, we can move on. You don't have to address the court if you don't want to. All right, Ms. Bates, first of all, could you please put your hand up? I need to swear you in. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, and what's your full name?
Quidisha Bates.
All right, and Ms. Bates, are you the individual involved with the case of State versus Sapita Carter? You need to say yes or no. Please repeat your response.
Yes, ma'am. Can you hear me?
I can hear you. Your broadband or your Wi-Fi is not very stable. Do you have anything to add, or you don't have to say anything if you don't want to? I can move on without any input.
No, ma'am.
Okay. I just need to ask you two questions. Are you still living with Mr. Carter?
No.
Okay, so you've moved out. And that's it. I only have one question then. Okay, thank you. You may mute your screen. Thank you. Anything else, Ms. Reed?
That's it. I mean, we're just concerned with his violent history, and that's the reason we're asking for the $3,000 surety bond. And of course, with her expecting to give birth in 2 months, you can make a determination on how they can do a third-party transfer if necessary.
Thank you. Ms. McLeod?
Yes, Your Honor. My client is 30 years old. He is gainfully employed. I would ask the court to note that this incident allegedly happened almost a year ago. My client tells me that since that time, he and the complaining witness have been speaking to each other. They are expecting a child in November. They are on good terms. I had the opportunity to actually speak with her myself today, and she tells me that she is not in the least bit afraid of my client or anything, and has no issue whatsoever interacting with them. And she did mention to me that they are expecting a child together. I would ask the court to take that into consideration, given that there's been almost a year since this incident allegedly happened, and there has been no further incidents whatsoever between my client and her. She's on here, she's listening to all of this, and this is what she has indicated to me, that it was just an off situation which she expressed regret about, and so did he, Your Honor. So based upon that, I would ask the court to give him a signature bond so he can get out. He is employed, he's working, and he is expecting a baby who he would like to be involved in the life of this child and should be given that opportunity, Your Honor. And I do not believe that she objects to that.
Bond is going to be set at $2,500. It's a surety bond. Next court date is September 22nd. He is to have no further contact with Khadisha Bates. Any contact with the minor child, once it comes into being, is going to be established through a formal legitimation action, which he would need to file with the Superior Court in the appropriate county. Custody and visitation of the minor child, once it comes into being, will be established by a Superior Court order from a properly filed legitimation action. Mr. Carter is not to consume any illegal drugs, not consume any alcohol, and once he is released on bond, he would need to complete a 6-month domestic violence intervention program at his expense. That program must begin within 60 days of being released. His next court date presently is September 22nd. Thank you.
Thank you, Judge.
Thank you, Your Honor, that concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, you have a good week. Thank you.
Thank you.
Position 3, Crane.
We have Darius Crane, 22 CR 006-033A, accused of simple battery domestic violence from September 7th, 2022.
This 8th arrest. Last was 2021. Failure to appear out of Cobb County.
2021 was what?
Failure to appear.
Okay.
On probation in Douglas County. Possession of a Schedule 2. 2020 arrest out of Kentucky for assault 4th degree. DV. Says minor injury. That appears to be open. There's no disposition. And 2016 out of Missouri. Domestic assault. That was dismissed by the court. 2018 possession of a controlled substance. That's it.
Thank you. All right. I'm sorry. I have someone in the courtroom. Ma'am, which case are you here for? This one. Darius Crane? Okay, you can come all around and sit on the bench right here, please. And don't use those double doors. Just walk. If you want to say something. If you don't want to say something, you can remain seated. Okay. Okay. Ms. Reed?
Thank you, Judge. On this case, the state is asking for a $2,500 surety bond. The reason we're asking for the surety bond is because this is the second time the defendant's been accused of domestic violence against the victim. Her name is Joanie, Joannie Garcia. So for those reasons, we're asking for a no further contact with Ms. Garcia. We're asking for a third-party transfer with their child, no drugs, alcohol, or weapons. Per the warrant, the defendant's accused of grabbing Ms. Garcia and shaking her until she felt dizzy. Our office has had contact with her, and she says that this has happened in the past. She mentioned the Kentucky incident that was in 2020, where the disposition is not showing. Ms. Garcia also told our office that she doesn't fear the defendant, but she does only want contact for their child, and she is unable to appear by Zoom today.
Okay.
Thank you.
Ms. Joanie Garcia, are you present? Okay, I think I have Mr. Darius Crane's sister in the courtroom.
I'm here.
Okay, all right. Ms. Garcia, if you want to say anything, you would need to be placed under oath. Would you? Do you want to say something? Okay.
Yes.
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
All right. And what's your name, please?
It's Guadalupe Joannie Garcia.
All right. And how do you know Darius Crane?
That is my partner, as in my boyfriend.
Do you all live together presently?
No, we never lived together.
All right. And how old is the child that you share with him?
She's 2.
2 years old. Okay.
Yes.
And was she born in Georgia, in which county, or somewhere else?
Yeah, she was born in Cobb County here in Georgia.
Cobb County. Okay. Thank you. Are you comfortable with having contact with Mr. Crane?
Yes, I am.
This is the second case.
I'm sorry, what was that?
This is the second case.
Yes, ma'am, I understand.
Okay, thank you. If you have nothing else to add, I can move on.
Yes, I have nothing else.
You can mute your screen. Thank you.
Thank you.
Ms. Gant?
Thank you, Your Honor. Darius Crane is 29 years old. He has been in the Atlanta, Georgia area since 2005. As we heard from Ms. Garcia, he shares a 2-year-old. He also has another child, a 5-year-old, for which he pays child support. Mr. Crane has a high school diploma. He also has college credits, business administration. He stopped attending college in 2017 due to the death of his mother, and he has never had the opportunity to return. He is currently employed at Delta. In fact, he just started that job this week, Your Honor. He denies the allegations strongly. When I spoke to Ms. Garcia, she indicated that she wanted to have contact with him, as does my client. We also heard about his history, Your Honor. I did not hear about any convictions for violence, Your Honor. He is presumed innocent in this case. In any open cases, I am requesting on his behalf a signature bond. If Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000. And again, we are opposed to any no contact and stay away orders. And if Your Honor determines that he should not have contact, then we would ask for a third-party transfer of the children. Thank you, Your Honor. Of the child.
Okay. Bond is set at $2,000. It is a surety bond. No further contact with Joanie Garcia. He's not to contact her by phone. He's not to contact her through a third party, not in person, not through any electronic device, and definitely not discuss her on social media. He is not to have any contact with the minor child. If he seeks to have any kind of shared custody or visitation with the minor child, he may file the appropriate legitimation action in the Superior Court and obtain a court order establishing visitation and custody. No illegal drugs, no weapons, no firearms. And once he is released on bond, He must undertake a domestic violence intervention program. He must enroll in that program within 6 months, within 30 days of being released. And that program will be paid out of his own pocket. As I said, no illegal drugs, no weapons, and no firearms, and no alcohol. I believe that's it. Thank you. Next court date is September 22nd.
Thank you, Judge.
Your Honor, I do respect the court's rulings. However, I would just bring to the court's attention that it is likely that Mr. Crane will lose his job and not have the ability to afford that class. I would ask that Your Honor impose maybe a one-day anger awareness.
Ms. Gant, I would have been inclined to agree with you, but this is a second open domestic violence case involving the same victim. That's a very serious situation. This is not a remote incident. He does not qualify for a signature bond. And please remember, you and I did not place him in this situation. Thank you.
Thank you, Your Honor.
Position 5, Harrell.
What happened with Furman?
Do you have Corde Furman as well, Francois? No, we'll find out. Alan James Harrell is accused of battery domestic violence from September 7th, 2022. Mr. Harrell, you've been advised of your right to remain silent, and your attorney will be Ms. Wanda Gant. Your accusation number is 22 CR 006 030C. Mr. Tusa? Is that a first arrest?
No, I was looking. This is 4th arrest. Last arrest was 2009 though, for counterfeiting 2nd degree. Failure to disclose original recording 1st degree out of New York City. 07 trademark counterfeiting. He was arrested in DC in 91 for simple assault. That's it.
Ms. Reed?
Thank you, Judge. The state on this case is asking for a $2,500 surety bond, a no further contact with his wife, Rebecca Harrell, a stay away from the primary residence, 4447 Favored Way in Union City, a one-time law enforcement officer escort back for the defendant to retrieve his belongings, and a no drugs, alcohol, or weapons while out on bond. Per the warrant, they had an argument, it turned physical, and he grabbed her by the neck. He pushed his wife up against the wall and washing machine. Our office has spoken with Ms. Harrell, and she said that she had to obtain medical attention due to her neck and back pain. Ms. Harrell also told our office that nothing like this has happened before, but she is afraid of what will happen when the defendant is released. She stated she wanted no contact with the defendant and for him to stay away from the primary residence, their house. And I believe she's going to be on Zoom, but she told our office she doesn't wish to speak, but you can of course sound for her. And if she wishes to speak, that's fine.
Ms. Rebecca Harrell, this is Judge Law. If you would like to add to these court proceedings, you're more than welcome to do so. Otherwise, you have a right to not say anything at all. All right, Ms. Gant.
Thank you, Your Honor. Mr. Alan Harrell is 49 years old. He has been in the Atlanta, Georgia area for 12 years. He is married and has been so for 4 months. He states that prior to his marriage, he and his wife were together for about 3 months. He has 2 grown children, ages 29 and 28. We are opposed to the stay away at the incident location, that is the marital home. However, Your Honor, I was unable to connect with Ms. Rebecca Harrell, and we will defer to the court's ruling. Mr. Harrell obtained a GED. He went on to study carpentry and HVAC. At this time, Your Honor, he is owner owner-operator of Harrell's Transportation and Logistics, and he has owned and operated this company for the past 2 years. He strongly denies the allegations, and I am requesting a signature bond on Mr. Harrell's behalf. He is recommended according to the report that I received, and we did not hear about any convictions for violence, and his history, of course, is quite remote. Last arrest in 2009. Again, we are opposed to the no contact and the stay away orders, and if your honor orders such, then we would ask for a one-time law enforcement escort to retrieve any belongings. Thank you, your honor.
$3,500 signature bond for pretrial services. No further contact with Rebecca Harrell, to stay away from 4447 Favorite Way in Union City, Georgia. He may return to the marital home one time only with a police officer to retrieve his personal belongings. He's not to consume any illegal drugs, no alcohol, and not possess any weapons or firearms. Yes, Mr. Harrell.
Mr. Harrell, please do not speak. If you have any questions about your bond, I will give you a call.
No, it's not about my bond.
I don't want you to say anything to jeopardize your case, sir.
Okay.
Please remain silent.
All right. Like I said, he may return to the marital home one time only with a police officer to retrieve his belongings. Within 30 days of being released, he must update the court with his new address so we can send him his new court summons as to when to appear in court. He will report to pretrial once a month. And if he fails to appear in court, if he fails to report to pretrial, or if he gets arrested again for anything else, his signature bond will be canceled and convert to a cash bond or a surety bond. Once he is released, he is to, not yet, Holly, one more thing. Once he is released, he is to enroll in a domestic violence intervention program within 60 days of being released, and he will complete that program at his own expense. Make sure that you report that you are attending classes to pretrial and that those classes have begun within 60 days of being released. Thank you.
Thank you, Judge.
No, that's okay.
Number 4, Mr. Furman.
Corde Jalen Furman is accused of criminal trespass and damage to property on May 30th, 2022, in case number 22 CR 006031F. Mr. Furman, you have been advised of your right to remain silent, and your attorney is going to be Ms. Gant. Any priors, Mr. Toussaint?
This fourth arrest. All right, hold on. Last arrest was August 7th. Felony theft by receiving, failure to appear for obstruction. May 2022, Snellville, obstruction, battery. The obstruction was a conviction. Oh, his first cycle was a juvie arrest. So he just had the open case in Gwinnett.
Okay.
For the theft and the battery. That's it.
Thank you. Ms. Mitchell, Ms. Reed?
Hi, Judge. Thank you. For this case, the state's asking for a $1,000 surety bond, a no further violent contact with his mother, Felicia Durham, and no drugs, alcohol, or weapons while out on bond. The reason we are asking for a surety bond is we're concerned because of his age. He's only 20 years old. And within this past year, 2022, he's actually had 3 arrests. Per the warrant, he was at his mother's house and they got into an altercation, and he broke a frame around a painting. Our office has made contact with Ms. Durham. I believe she will be on the call. She said that something like this has never happened before, and she does requesting a no further violent contact. Thank you.
Thank you. Mrs. Felicia Durham, if you want to contribute to the proceedings, you would need to start your video and your audio. Otherwise, I'll move on. All right, Ms. Gant.
Thank you, Your Honor. Mr. Corde Furman is 20 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mother. We are let's see here. I don't believe that there was a stay away that was requested. We are opposed to, we are unopposed to the no violent contact order, as I did have the occasion to speak to his mother, Miss Felicia Durham, as well. She informed me that she wants to continue having contact with her son, as does my client. Mr. Furman completed the 11th grade. He is now taking steps to obtain his GED. He is unemployed at this time, Your Honor, and again, he denies the allegations. He's presumed innocent. I am asking for a signature bond. I do acknowledge that my client does have some history. However, I would just appeal to the court to considering the nature of the allegations and the fact that he does not have the means to pay anything toward bond. I am requesting that signature bond. And again, we are unopposed to the stay away. Thank you, Your Honor.
Thank you. Ms. Durham, my name is Judge Law. Did you want to address the court?
Yes, can you hear me?
Yes, could you please raise your right hand?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, how do you know Corde Jalen Furman?
He is my son.
All right. And this location at Glenridge Drive, is that a rental property or do you own it?
It's a rental property.
It's a rental property? It's your
Yes.
apartment?
Yes, ma'am.
And have things been righted?
I'm sorry?
Have everything been recovered and repaired?
Yes, ma'am.
Okay. What would you like to tell me?
I just wanted to let you know, Your Honor, that the incident that happened at the house, I'm trying to use the right words. Even though the police was called out, I don't want to like press charges on Corde, so I will show up in court so that he don't have to face this. So I was wondering if you can give him a signature bond, and I will make sure that he does show up to court.
Right. So the decision to pursue prosecution is with the Solicitor General's office. Unfortunately, once the case is accused, it's not really up to the alleged victim.
Okay.
All right.
Okay.
Ms. Gann, did you have anything else to add?
Just, Your Honor, that my client is presumed innocent. And
Okay.
we are again requesting a signature bond given the nature of the allegations.
Bond is set at $2,500. It's going to be a signature bond through pretrial services. He's to have no violent contact with Felicia Durham. In other words, he can be with her in person, communicate with her, but there cannot be any physical or verbal altercations. And if there are, then, well, he'll be back in jail and he just needs to bring $2,500 with him. He is to stay away from the entire apartment complex at 5755 Glenridge Drive in Sandy Springs, Georgia. Yes, your mom may be living there. Yes, she may have rental property there, but the ownership of the property is separate from the rental ownership. And given the nature of the circumstances, I'm going to have you stay away from the entire apartment complex. If you and mom want to see each other, she will have to come to you. You cannot go to her. Is that understood, Ms. Durham?
Yes, ma'am.
And hopefully Mr. Furman understands that, because if he's at your property and something happens and he's arrested there, he will jeopardize losing his bond and he will be in a much worse situation than he is presently.
I understand.
Simple as that. He'll be reporting to pretrial services. He will attend and complete a one-day anger awareness class. No illegal drugs, no alcohol, no weapons, and no firearms. He'll be subject to random screens for illegal drugs or alcohol consumption. His next court date will be sent to him at his current address. Do we have a current address on Mr. Furman?
The address, well, he doesn't live there. I can send that information to Ms. Bridgewater.
All right, so as long as we have a current address on him, if he fails to report to court, if he fails to report to pretrial, or if he gets arrested again, he will lose his signature bond. It might be a no bond status. Thank you.
And Your Honor,
this is per judge.
Yes, sir, for judge.
And Your Honor, if I may I request a one-time law enforcement escort? He tells me that he does have belongings at his mother's home. He doesn't live there, never lived there, but he has belongings there.
Mom can bring it to him. He's not going there.
All right, thank you, Your Honor.
Okay, that's fair.
Thank you, Your Honor.
Thank you.
All right, next case, please.
That's it, but I don't have no more files.
Francois, we've completed?
Your Honor, we still have the breakout room case.
Oh, that's right. Position
8 and 17.
Okay, before I go into the breakout, let me just go down the calendar. Norma Brown is $1,000 surety, reset to September 22nd. Corde is a 2,500 surety, reset September 22nd. Crane is 2,000 surety, September 22nd. Furman is a 2,500 signature bond pretrial per judge for the notice. Harrell is a 3,500 signature bond through pretrial for the notice.
How do I get out of this?
Ms. Durham, you might want to mute that screen.
Oh, sorry.
Position 6, Henry is a $1,500 split bond for the notice September 22nd. Jones is a $2,000 surety bond, reset September 22nd. Position 8, Maddox is released on bond. Position 9, Mason is a $3,000 signature bond for pretrial for the notice. McNeese, position 10, is a $5,000 signature bond for pretrial for the notice. Position 11, Meadows is a $3,000 split bond, reset September 22nd. 12, Morris is a $6,000 signature bond for pretrial for the notice. 13, Parker is a $500 surety bond, reset date September 22nd. Position 14, Pfeiffer is a 2,000 signature bond through pretrial for the notice. Russell, position 15, is a $1,000 surety bond for the reset September 22nd. 16, Smith is a $500 surety bond, reset September 22nd. 17 is a breakout. 18 is a $2,000 signature bond for pretrial for the notice. 19 is a $1,500 signature bond through the jail for the notice. And the add-on is a $250 signature bond through the jail on the additional charge of failure to report striking a fixed object. All right. So I'm going to go into a breakout with regards to McCaz Williams. Mr. Williams, please remember that you have a right to remain silent, and your attorney is Ms. Wanda Gann.
No, it's Jay.
Ms. Kim, all right.
And Your Honor, this concludes my business, maybe.
Yes, thank you, Ms. Gann. All right. Who's going in the breakout with me?
Your Honor, we need to add Ms. Ekpo as well.
All right, thank you. Ms. Champion or Mr. Jordan, I'm not sure who's hosting. Please place Ms. Kim, Ms. Mitchell, Ms. Ekpo, and myself in a breakout room, please.
You want me to leave too? Damn, she left.
All right, is there anyone on the Zoom who is here on behalf of McNeese Williams? This is the time to start your video and your audio.
Hello, I'm his mother.
Miss Robinson, please, are you in a room with somebody else on Zoom?
My daughter.
Okay, you need to be in a separate room because otherwise we're gonna get a lot of audio conflict.
Okay.
And Marceline, I can only see you sideways. And what's your name?
Denisha Robinson.
All right, so your sister.
Yes.
All right, Miss Robinson, please raise your right hand. Do you
Which
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Miss Robinson, do you live with your mother in Fulton County, Georgia?
Yes, I just moved here 3 days ago.
All right, did you move here permanently?
Oh, yes, and I was trying to get me a job and get my own place for me and my children.
And what progress have you made in that area?
I have an interview on Friday for a job, and I've been looking for somewhere to move.
Okay, thank you. Miss Watsika Robinson, you may please mute your screen, Miss Marceline.
Yes, ma'am.
All right. Miss Watsika, are you Miss Watsika Robinson?
Yes.
All right, please raise your right hand. I can't see you. You need to be in a room with light. All right, that's good. You can stop right there. Perfect lighting. Nope, nope, you moved too far. You need to just stop. Perfect. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Miss Robinson, this location where your son lives at Pheasant Trail, is that your home?
Yes.
Do you rent or mortgage that home?
We rent.
Okay. And I understand that Miss Denisha Robinson lives with you presently with your granddaughter. Is that correct?
Yes, they just got here.
All right. Is there anything else you'd like to tell me?
Me?
Yes.
Yeah, my son, he doesn't have anywhere to go. So I think we can work this out with us. Because that's my son, that's my daughter, and I love them equally. I just hate that it had to even come to the altercation that they had.
All right. Thank you. You can please mute your screen. Thank you. Okay. Mr. Tucson, any priors with McNeese Williams?
Oh, I don't know. I put the files up. I thought I gave the history. Did I not?
I forgot, Tucson. I'm old.
Oh, well, I got to go and get them unless the state got it, because I already took them up to the front.
I believe Ms. Mitchell mentioned that he has an open case in Ohio.
Oh, no, there were 2 domestic violence cases, one from this year and one from 2020 in Ohio. They were both dismissed, but they both involved the victim.
Denisha Robinson?
Yes.
Okay.
That sounds about right. I'll go get it. I'll be back. All
Yes,
right,
sir.
fourth arrest, 2019, unauthorized use of a motor vehicle, joyriding. That was dismissed. November 2019, domestic violence dismissed. February 2022, domestic violence dismissed. That's it.
Were the November and the February DV cases in Georgia, or were one of them from out of state?
All 3 of his previous arrests come out of Ohio.
Okay. And he just moved to the, from what I understand, he just moved to the state 2 months ago?
I don't know.
To Georgia? Ms. Kim?
Yes, Your Honor. 2 months ago, he moved here.
Okay.
About 1 year, he was in Ohio. Before that, about 2 years and 10 months, he was in Georgia.
Okay, thank you. On the battery matter, the bond is going to be set at 2,500. On the cruelty in the third degree, that's going to be set at 1,500. That's a $4,000 surety bond. He is to have no further contact with Denisha Robinson. And as long as Miss Robinson resides at 6367 Pheasant Trail in Fairburn, Georgia, he's not to return to that property.
All right, can I say something?
Nope. He is to have.
She gonna go home because my son need to come home. She gonna go back to Ohio because he live here.
All right. If you let me finish, we can get
I'm
through
sorry.
this. He's to have no further violent contact with Denisha Robinson. Now, he can return to 61, if he makes bond, he can return to 6367 Pheasant Trail, Fairburn, Georgia, one time only, with a police officer to retrieve his belongings. If the officer verifies that Denisha Robinson and her daughter do not live at that location, he may then return and live at that location. So because Mr. Williams now has a no further contact with Denisha Robinson, he cannot call her, he cannot speak to her in person, he cannot communicate through a phone or electronic device, not through a third party and not through social media. His next court date is going to be September 15th at 9 a.m. at the MH Court. And Ms. Kim, if you want to get in touch with Ms. Robinson and give her information on how to connect with that court after you discuss that with Mr. Bartell. Ms. Robinson, do you have any other questions?
Your Honor.
So he don't have a bond?
Yes, a $4,000 good bond.
A who? You
Yes,
said a
Ms.
what?
Kim?
I'm sorry.
Just 1 second, Ms. Robinson. Yes, Ms. Kim, what's your question?
My question was just in case he's not gonna be, if he doesn't get qualified for September 15, can he have a backup plan as to come on September 22 for SAP calendar, since he got the surety bond now?
I'm not sure how to put that in there, Holly.
I'll set him down and then we can make a determination at the 15th calendar whether or not he'll proceed over to the SAP calendar on the 20th.
So we set him on both calendars? We'll set him on both calendars, September 15th, MH, and September 22nd, SAP.
Thank you, Your Honor.
Okay. The third thing is no illegal drugs, no weapons, and no alcohol, and he must be medically compliant. All right.
What does that mean?
Ms. Robinson, what was your question?
What does that mean? You said medically compliant.
Well, if he's undergoing any kind of treatment or if he's required to take any medication, he needs to comply with all those requirements.
Okay, so do I have to get him out or something? I'm not understanding.
On what portion do you not understand?
I don't understand. I don't understand any of it. I don't understand. Like, does he have a bond that has to be paid or?
Correct.
I don't know how to.
I
So
just answered
he
your
what's
question.
the-
He has a $4,000 bond. If you want to release him on bond, you have to go through a bonding company. They charge between 10 to 15%. Otherwise, you can put up security or you can put up cash bond. But he has to
So
comply.
he don't get the other one? Why can't get the other one where he does signature?
Because he's had prior incidences involving the same alleged victim. Thank you. That concludes this case.
So he got to stay there, right?
He's got a court date on September 15th. If that court does not accept his case, then his next court date is September 22nd. Both of them are at 9 a.m. and they are available through Zoom. Anything else, Ms. Robinson?
If she go home, do he still got to stay there?
If she's no longer at the premises, then we can consider a bond modification either on September 15th or September 22nd.
Okay, so he got to stay there till then, basically.
Unless he bonds out.
All right.
Thank you. All right, anything else, Ms. Kim? Ms.
Nothing
Mitchell?
further.
All right, that concludes this case. Francois, we are done. Thank you very much.
Thank you very much.
Everyone, have a good day. Thank you.
Okay, thanks.
I'm mad as hell.
Oops.